You are listening to Lone Star Community Radio on 104.5 KCZW LP Conroe and 106.1 KZCC LP Conroe and worldwide on irlonestar.com.
Hi, welcome to the Legal Connection Show. I'm Tony Collins, and the Legal Connection Show is a community service show that airs on Tuesdays between noon and 1 on FM 104.5 and FM 106.1. You can also get us on Facebook at the Legal Connection Show. Had its own Facebook page, and you can go to irlonestar.com where you can also catch all the episodes if you miss them on the radio. And so we do, I say we, my co-host Cheryl Jahani is not here with us today, but what we do is we just answer legal questions for the community and sort of give y'all some insight that you might not have necessarily through your experience or just not being able to afford an attorney. So I'm going to go over a couple of things that have happened to me in the last week that I think would be beneficial for the public to know. The first is when you get tickets in the small municipal courts around the Montgomery County area, and this would apply to basically any county and small towns in Texas. A lot of these small cities are, I don't want to call them speed traps, but really their revenue is generated through tickets. And so you'll get more tickets more often in certain areas. In the first one that comes to mind is Shenandoah. If you go too fast down the service road on 45 North between 242 Research Forest and I think the Woodlands Mall, you're more than likely going to get pulled over. And then if you go to the other side of the street, you've got, I forgot what the name of it was. It's the small jurisdictions of it. I've been in that so many times. It's off of Robinson. But anyway, there's another small city on the other side of the freeway going north. That Shenandoah is going south on 45, going north on the feeder, and they will pull you over there, particularly with all those bars all the time. You will get pulled over for DWIs and going over 45 down the feeder if you're trying to make it to one of the stores before they close. So anyway, I had a client who got pulled over, and I was going to talk about that a little bit today and what you can do about those tickets. So small municipal courts and tickets. Another part of this today's show is going to be a segment on pre-suit depositions in Texas. It's kind of a little-known statute that's available to litigious, whatever the term is for people that like to be in court a lot, because I don't think they have anything better to do. We're going to talk about that. Basically, it's a procedural rule that is complex and confusing to non-lawyers, but it's in the Texas Rules of Civil Procedure at 202, and it is basically a way that someone can get your deposition under oath and interrogate you, and you never want to do this without an attorney, about something that they want to investigate. It's not even really a claim, so you have to kind of be aware of that. We're going to talk about how you can address that if you get it. And the last is we're going to hook into the last bit of the show that we were talking about last week, which was on homeowners associations, and when you are, I guess, pinpointed by your HOA, or they've determined or sent you a notice that you're in violation of one of the deed restriction deed restriction covenants, are the ACC board, which is the architectural, what does the ACC stand for? Architectural Content Committee, Architectural Construction Committee. I can't remember what it stands for. Anyway, the ACC will come after you if you haven't done something right on your property. And man, I can't remember what the code, the ACC stands for. I should know that. Architectural, losing it. Okay, let's go to the first topic we're going to talk about today, which I think is really interesting for people. If you've been, and people that don't get pulled over by police are perfect angels on the road, have no road rage, never speed, are sticklers for following every single rule, then you don't have to worry about this. For the rest of us in society, and I've learned this not on my own, but through my clients, that you can get tickets if you're pulled over. And I know that through on firsthand. But you can also get tickets if you're pulled over and you're committing a crime. And a lot of people don't know that the ticket kind of hooks into that crime. And most of the time, there is not a ticket associated with whatever the crime is, which is crazy. You would think that if you're, evading the police, if they're after you and you don't stop, or if you were, speeding or whatever the improper lane change, whatever it was that you were doing that the police stopped you for, you would think you would get a ticket. But a lot of times you don't get a ticket, but you'll get arrested for some other crime that they've determined that they want to charge you with. And so the example I have today is I had a client that was pulled over for DWI. And, that's still pending. We may very well be able to fight this, and he will be exonerated. We've had many, many shows on DWIs, and you can go back on IRLoneStar.com and look at our past shows on that. So we're not going to get into the nitty gritty of those. But the bottom line with DWIs are that many times if you say nothing, regardless of whether or not you are intoxicated and driving, if you say nothing and refuse to give a breath test or a blood to give a blood sample, a lot of times you can beat the DWI even if you are driving while intoxicated. And it will cost you a lot of money. You will learn your lesson. I hope never to do that again. Most people I know that are just trying to get home from wherever they were when they were drinking, whether it be a game or a football game or a going out to eat or a party. People just want to get home. And that's when the police are out looking for you, because you can hurt people if you're driving while intoxicated. And usually once you're stopped, you usually don't do it again if it's an anomaly. A lot of people are alcoholics and they're driving all the time intoxicated. And so it's just a numbers game and they're going to get pulled over. Those are the people that have more than one DWI. You would have thought they would have learned, but they don't. So I had a client that's never had a DWI before, and he didn't know what to do. In fact, he's never even had any tickets. He is, I believe he's here legally. I don't know. Don't remember asking him that, but he had a driver's license. And he was trying to get home from work. He'd gone, I don't know what it is about fishing after work, but a lot of my clients fish after work. He was leaving where he worked. He went fishing. He stopped off and had something to eat at a taco stand, and then was on his way home and got pulled over in Patton Village, a very small town that has a reputation for pulling people over and giving them tickets because it generates their revenue for Patton Village. Patton Village, if you don't know where that's located, it's off of 59 going north. Kind of, how do I describe it? It's, you will, if you go down 242 and just keep on going, from between 45 and 59, and then take a right on 59, Patton Village is close to Roman Forest. And I think if you go a little bit, if you keep on traveling south, you're going to hit Kingwood. So it's sort of in that area. It's very, very small, nice little area. Anyway, my client was pulled over by the police for driving without a license plate on the front of his truck. That is not uncommon not to have a license plate on the front of your car. European cars aren't made to have a license plate up front. We've gotten pulled over a number of times for it. And the way to beat that rap is basically just to put the license plate on and show the law enforcement agency that gave you the ticket, and they usually only give you like a $5 fine or something, and the ticket goes away, instead of the $331 fine by statute that they will hit you with. But if they can get you for anything else, they will. And again, it goes toward the DWI. If it's on a Monday through Thursday, and you haven't really done anything else wrong, and let's say you really were driving while intoxicated, if you refuse to give your blood or your breath, then they can't get a warrant. Or my understanding is the rule in Montgomery County is the judges won't grant a warrant because then we'd be bothered by it. So Monday through Thursday, you're driving at night, you get pulled over, you get pulled over for DWI. Don't say anything. Don't consent to anything. Be polite. Step out of your car if they ask you to, but don't give them permission to search your car. And then more than likely you'll be able to beat that rap. However, you might still get a ticket. And if you get pulled over in Patton Village, you will get a ticket. I didn't know that until I started representing a client. I've done quite a few DWIs in Patton Village, and I don't know why I didn't remember this, but they're one of the few jurisdictions that actually will not just arrest you. And you're usually arrested and taken to a small jail and then transported over to Montgomery County's jail over on First Street, but or wherever their closest jail is. Patton Village will issue you a ticket. And if you're arrested and you don't speak English, like my client didn't speak English, you may not know you've gotten a ticket. And I don't know yet if he was actually sent a copy of his ticket, but he was called. His arrest was about 6 months ago, and we were just waiting for the videos and the various things to be able to go forward. And with COVID, things are very, very slow. So his DWI case is pending. Well, I get a call from his family, and they're, panicking. They're like, "You didn't show up for court. He's got a warrant out for his arrest." And I'm thinking, maybe I didn't show up for court. Maybe I've, become very lax. I've never missed a court date. So that sort of shocked me. And then I looked it up. I pulled up all my records. I just happened to be home when I was getting these phone calls. And I hadn't missed his court date. He was within my time frame. They had told me that the court didn't have me assigned as the attorney of record. I knew that I'd made an appearance, so that wasn't right. So they gave me, they said this, that a person was calling them and telling them that he had a warrant out for his arrest. And they thought it might have been a hoax, which it could have been. People call all the time from the IRS, these phony phone calls. You get these people pretending that there's somebody like this happened to my son's grandmother. My ex-mother-in-law got a call about my son, who's, at the time was in his late 20s, saying that he had a warrant out for his arrest. He had, the IRS was after him. Somebody was after him. And she ended up paying like thousands of dollars to these phony people because she was trying to protect my son, which was insane because my son didn't have anything against him. So they just took her money. In this case, I asked them not to do anything but to give me the number of the person that was calling them. They gave it to me. I was able to determine that it was the Patton Village Police. Called the police officer back, or the deputy, who said that my client had a warrant out for his arrest because he failed to appear. It was it was an FTA. I don't know why they call it that, but it's failure to appear. I don't know what these things stand for. I'm having a bad time with that today. Architectural ACC, the Architectural Committee, something. I don't know what it stands for. Anyway, they call my client. I call him back. He confirmed that there was a warrant out for a failure to appear for 2 tickets that were issued to him. I found that the date they were issued was the same day he was arrested for the DWI. One was for an expired driver's license, which I don't know to be expired because they took his driver's license. So I need to look at that so I can develop his defense. And then the other was for missing a front plate. He just has to put that on there, and I need to prove it. And then that will be disposed of that way. He'll be found, they'll exonerate him. And the third's the failure to appear. That I don't know about. So I asked them if they could put me on the docket. I filed a notice of appearance for him. I'm not charging him for this because I just want to, see what I could do for him. I felt really bad that I didn't ask him when he was arrested for DWI, whether he had any tickets. Normally and then when people get the tickets in the mail and they let you know about it, you go take care of their ticket. But he didn't know about it. So Patton Village actually has on every Tuesday night at 7, I learned, they have court. And as I recall from about 10 years ago, court is a bunch of folding chairs in a room. A small room, and it's very loose. But anyway, so I called this gal and she said she put me on the docket. I haven't heard back from her. But it occurred to me, and I wanted to share this with our listeners, that in Houston, I believe in Montgomery County, and in many of the larger jurisdictions, in their municipal courts, when you get a ticket, they typically don't give you tickets when you are actually arrested. And I know that because I used to try to fight it as part of my defense is, how could he have been speeding if he didn't even get a speeding ticket, being the reason that they arrested him for having what's called a PCS and all these initials today, that is possession of a controlled substance. And it's usually cocaine or pot or something. But normally they don't get the ticket that goes along or is the cousin to why they were arrested. And so it doesn't work as a defense, by the way. But in Patton Village, you do get a ticket. And so if you, and here's the guts of what I want to tell y'all, you can actually file for a motion for credit for time served. if you're actually arrested in Houston or in Conroe, and basically in any city, and you go to jail, it may not be the arresting law enforcement agency that actually takes you to jail. In this case, with Patton Village, I don't believe it was the Patton Village police that took him to the Patton Village jail. I believe that Montgomery County got involved so they could do the DWI test, and he was taken to the Montgomery County jail. Regardless of what jail he went to, if you go to jail, when you actually serve time, even if it's not for that offense, you can move for a credit for time served. The only jurisdiction that actually has a motion that you can use that I'm aware of is the city of Houston. If you Google the city of Houston municipal courts, or you just Google motion for credit for time served, you can actually use the city of Houston form and just fill in the blanks and just cross out city of Houston, make it city of Patton Village, city of Conroe, whatever the city is, and then you file it with that city's court. And then whether you're an attorney or not, you can do this, and then you follow up with it. Typically, if you have served time after the ticket or the arrest, then you can use that time served to exonerate you from the ticket. Now, you could plead guilt. You would be pleading guilty to the ticket, but it would wipe away all of your fines. And the flip side of that is if you didn't serve any time, not even one day usually will clear all of your tickets. And you have a lot of money that are due these jurisdictions because you're running through the toll booth, or you have a lot of parking tickets that you've accrued, or you speed a lot, or just any litany of things that you have. If you have a lot of tickets, you will have a warrant out for your arrest if you don't pay those fines and you don't show up and take care of them. But if you are arrested, it's only going to be one day until you are released. So what I do is in this case, I ask the court to hold off on executing on the warrant, even though they could find my guy. He only has these tickets, and the one crime he's ever been accused of, this DWI, which I should be able to take care of for him and get it disposed of without him having that on his record. You want to contact the city that you have the ticket in, and if you were arrested in conjunction with one of these tickets were given, ask if you can file a motion for time served. What I'm going to do is I'm going to go ahead and prepare a motion for time served for my client. I'm going to show that he already was in jail for the one night before he bonded out. See if all of his tickets can be exonerated, not even try to fight or defend the ticket first, to see if the time served will make it go away. If you have a lot of tickets, typically these tickets are not going to hurt you. It'll just show that you have a propensity for speeding or whatever, but it's not, Class C tickets are not things that you go to jail for. Failing to show up for court is something you go to jail for. So just kind of bear that in mind. And I'll actually show people on the camera. This is what the city of Houston, I don't know if you can see this or not, but the city of Houston Municipal Court's motion for credit for time served look like. It's just a fill in the blank form. And you can actually cross out the city that it's in if it's any small city around here and use it. But you can't just file it. You have to know where to file it. In the city of Houston, you file it with they tell you actually on the bottom to file it with the presiding judge. I actually email mine to the presiding judge. It's a lot easier, and you can kind of keep track of the fact you received it or not. But do that before, if you got a lot of tickets that are due, just don't go pay them. If you're willing to go to jail for a day, or if you'd been arrested and you have that time that you can apply, then do a motion for time served, and you should be able to get it rid of that way. All right, so that is the first thing. Another thing that came up, and I'm going to throw this out because it wasn't a topic I was going to talk about, but I want to just kind of get it out there. I've got some cases in Montgomery County probate court, and not a probate court is a statutory. If you have to do a probate, it's statutory. If a relative of yours has died, then you have some options. You can do probate as a minimum of title. You can do a small estate. You can choose not to probate. You can do a full blown probate. You can do. There's different types of probates that you can file if you need to access or distribute a deceased loved one's property after they die, or handle their debt or whatever. So, I've done a few of these in Montgomery County. I've done more of them in Harris County. But if you file for probate in Montgomery County, then I'm not sure how many different courts you can end up in, but it just so happens I've always ended up in county court too, Judge Laird's court. And recently I had a case that where the two brothers that inherited were fighting with each other about the brother that was designated the executor in the will, whether or not he properly distributed his father's estate. And so the brother that wasn't the executor filed for an accounting. And an accounting is very costly and not typical in probates. If everybody's happy, then with the way that things have been distributed, then you just file that your attorney, or if you do it pro se, will file per statute, and you can find these things online. They're pretty easy if you want to do it on your own, so you don't have to hire an attorney. You can file a certification of compliance, and that the case has been fully distributed and the case is closed by the court. Well, Montgomery County, they take this very seriously, and if you don't file your certificate of compliance or your the document that shows that the case is that the estate has been fully distributed, then you will get a call back from the court probate coordinator letting you know what you need to do to clean it up. Very hardworking coordinator will catch everything. If you have not dotted your I and crossed the T, he will catch it, and so you learn a lot from him. But in this instance, the brother that asked for accounting, we went ahead and we went to court, and the accounting is basically show every penny that's passed through that estate and through the estate account, and if there was one, and if it passed through properly, and to shore up that everything is in the T account properly done. And so we did this, and it was really a big estate. There was a lot of money involved, and when I finally did the accounting, it was just pages and pages of an Excel spreadsheet. You don't really use an accountant per se for this unless you want to pay one, and they'll charge you a lot. But really, you're just showing where the money from the time of death forward, what the estate owned in the inventory, what the value was, and how it was disposed of, and if the money was split properly between the beneficiaries. And that's easier said than done, because you may need to subpoena different vendors if you didn't keep the receipt and various other things like that. And so in this case, rather than do that, because we only had an argument over a few of the items, we ended up settling. Well, the settlement hasn't gone through yet, and so I got an email from the court coordinator that they are calling us to court. There is a show cause order. I'm not even sure if they told the party that asked for the accounting about it, but we have to show up under the threat of the executorship being pulled for court to explain why we have not properly given all of the accounting details to the court, which was puzzling to me, because typically you've got a party against a party. You don't normally have the court, intervening and becoming like a party to a suit. And so we reached a settlement, but we didn't actually, we hadn't signed off on it yet, because it was just literally one item out of thousands of items that was not set out properly in the settlement. It was just a descriptive item. And so what I'm having to do, because we didn't do all the subpoenas, because anything that the executor does has to be charged to the estate. And so anything that I was doing as the attorney for the executor would run the bills up for all the beneficiaries. And so you really want to avoid that if possible, because the only people hurt by it are the actual beneficiaries, because the attorneys win because we make the money for doing the work. And so they said, no, we're going to cut our losses. We're going to agree to this. We're going to settle. And so what I need to do is I have to file today. I have to file a certified notice to the court saying that we've reached a settlement. It's just we're tweaking it and kind of see where it goes from there. But I was just surprised that the courts get so involved in your business, unlike the Harris County courts that really just they won't, and the federal courts, they don't even touch anything unless you contact them. So just be aware, if you have a probate case that we have some pretty good probate attorneys here in Montgomery County, but if you don't follow up, pretty much with the statute to the T and follow the statute, you will have to answer to the court, not just to the other side. And that kind of reminded me about one other case that I was handling this week, which was just one more thing that y'all might be able to learn from. In federal court, if the judges pretty much have carte blanche rule over the way the courts are ruled. In one federal court that I was in, Judge Hughes' court, you can't ask for a motion. If you file something, that court will automatically put you on like a kind of a Rolodex clock, and they let you know when your motions can be. So you never ask for one. The judge will decide whether or not you're going to get a hearing, but the motion will be set for a status hearing, and he'll determine whether or not he wants to hear you in person or not. And I had a case in that court for 4 years, and he never got back with me. And I just thought, I don't know how much longer you wait to get a response when you've got a pending case, but lo and behold, it was. He said, "You're coming to court. I reviewed this. We're going to have a status hearing." So we went to court, and wasn't even a status hearing. It was his rendition. He was ruling on it after 4 years, and so we just went to court for that. It was really odd, and so but good, because it turned out in our favor. The order was in our favor on that, so that was a pleasant surprise. And but in a bankruptcy court we were in, I had a case outstanding. It was a case that in bankruptcy court, it's another weird deal where if you have a trial, if they don't have time to go forward with your case, they just abate it. They will just stop it and tell you when you can come back again. And there's very, very strict rules in bankruptcy court with regard to how you present admissible evidence and exhibits, and you have to follow it to a T. And so it's another thing you have to kind of look into if you're not familiar with that, or you don't have an attorney that's familiar with that. But in this particular bankruptcy court we went through, we had a bench trial. We could have had a jury trial. I've never heard people having bankruptcy bench trials, jury trials, and we didn't, but we could have. And so we went to the bench trial. We got all of our evidence in, presented our case, and then the trial actually it was over a period of, like, as I recall, maybe 6 months, because we had 2 days and then it was reconvened like 2 months later, and we had another 2 days and it was reconvened like 2 months later. Very patient judge, was like, you can have all the time in the world. There's no limit on this, like a lot of judges will give you, but you will have to we'll have to reconvene if you don't finish. And so we did that on the first case, and he, as I recall, he didn't rule in our favor, but we got that reversed. And so we had another case in the same bankruptcy court, same bankruptcy judge's court. And it's weird because the courts also aren't numbered. They're designated by the judge's name in federal court here in the Southern District in Houston, over there off Rusk. And so we had another trial, and we went to court. We were almost finished with the trial and getting ready to win, and the judge didn't want to. It was in bankruptcy you don't have trials unless there's an adversary that's claiming that you've committed fraud, or that their debt shouldn't be discharged in bankruptcy, which is what we were doing. And otherwise, bankruptcy is not. There's not a fact issue. You just go to your trustee, and the court decide whether or not you qualify for it. But we were actually going to trial and arguing that some debts could not be disposed of because they were the debt was how do I say, the debt was taken and it was surrounded by fraud. And when a debt is taken by fraud and not paid, basically not paid by fraud, then the bankruptcy court finds that it's tainted and you shouldn't be rewarded by it. And a good example of that is if there's somebody that a wrongful death. If you kill somebody and then they get like OJ, let's say, of course he was exonerated on his the murder case against Nicole Brown Simpson, but let's say that he, that's a good example. He was exonerated. They took him to court in civil court for wrongful death. He could have declared bankruptcy, which he might have. I don't know that much about the OJ case, but they got like a $33 million case against him. If OJ Simpson wanted to declare bankruptcy, if his assets were lower than his debts, and in this case they would have been, then the bankruptcy would have exonerated that debt, and Nicole Brown Simpson and Ron, I can't remember Ron's last name, Ron Brown, or no, it was Ron, I can't remember Ron. Anyway, the guy that also got killed, if he his family would not have been able to execute upon that judgment if if O.J. Simpson had declared bankruptcy and those debts were forgiven. Well, in bankruptcy court, if you kill somebody and it was determined by the civil court that he was responsible for it, then you can't forgive those debts. And so that's what an adversary case is for. If O.J. Simpson had declared bankruptcy, the Nicole Brown Simpson family could have gone to the bankruptcy court and filed an adversary case saying he can take everything else can be forgiven, but not our debt. He's still going to owe us $33 million because what he did was so bad. The judgment debt goes toward a bad deed of his. All right. So we were in court and we were getting ready to win on one of these bad deed debts, and the judge said, "Don't. I want to give you a chance to settle because I don't want the entire bankruptcy to go south if you can make a settlement." So he was trying to protect the bankrupt, and we did that. And then they reneged on the settlement that we entered, and so that was 2 years ago. We are still not back in court to finish that trial, and COVID had a lot to do with it, but we also had won on a you can do 727 claims and 523 claims. They're both claims when you claim fraud. One is 523 is your own particular debt was fraud, and a 727 is fraud was committed on the whole estate. So we had won the 523 claim, and we were coming after the whole estate because we didn't know we had won the 523 at that point. And so I had filed. I'm getting to the point here. I had filed a motion for confirmation that the stay was lifted because these cases are so old, and I never heard back from the court. I filed it, I don't know, I think months, maybe a year ago. I just can't remember when I filed it, but it was a long time, and I'd asked for a hearing, whether it be through Zoom or be in person, to go try to get this confirmation, because bankruptcy courts are, I think like most courts, it's better to get permission than forgiveness in court every time. Don't mess with the courts. You can do it with your spouse or your friend, and even with HOAs like we'll talk about today, you can try to cross that line. But in courts, could not comply with a court order. Always get permission if in doubt first. Probation is a good example. A lot of my clients are on probation, or they have terms, conditions of bond, and they can't leave the county or contiguous counties, but a lot of them have work outside the county. And so always best to contact your attorney and ask them just to approach the bench to make sure the judge says it's okay. They are always will give it to you if you ask, but if they find out you did it without asking, you're in big trouble. So always permission, not forgiveness, when it comes to do with legal issues. So I had filed this motion for confirmation that the stay had been lifted because I figured it had been and I'd met all the rules. And I out of nowhere, I got a motion from the court, which always scares me because I don't know what they're sending me if I'm not actively dealing with that court. And they granted my motion. So that was kind of a happy thing out of nowhere that came to me. So in federal court, you will be surprised. You will suddenly get a motion or an order that you didn't expect out of nowhere. And just to kind of add to that same thought process, I had gotten an order against me and my client, or actually it's my client, in federal court. And I filed a motion for reconsideration. Those things don't even exist. There's no such thing as a reconsideration in the federal rules. But I filed it anyway, and I forgot what the terminology was, but I thought there must be some mechanism to do this. And I had written this case off, and I was just waiting for the final order to be signed so I could file an appeal to the Fifth Circuit. And in this case, I could have gone to the United States Supreme Court because it was a land issue, but I didn't. And lo and behold, I was granted my reconsideration. We were back in court. So the rule of thumb is always ask for permission, not forgiveness, and never give up because you never know. It's rare that you get the same judge that has ruled against you to give you a reconsideration on something that you just thought that they were dead set against. And then sometimes they do. Then you're back in court. So do not give up. File your motion for reconsideration or motion for new trial. But I don't remember if that was what you asked for in federal court. I always get my different courts confused. Just read the rules. Even if you're not an attorney, if you have some snap, you can go forward with it. All right. That leads to our next segment, and it was something that I wasn't familiar with and that we got hit with, one of my clients, and I was surprised. It is a Rule 202 pre-suit deposition in Texas. It's under the Texas Rules of Civil Procedure. You can't just take someone's deposition, but if you want to harass them and you want to run their legal bill up, You can do this Rule 202 pre-suit deposition, which surprised me. And you can do it with a court reporter. You can do it with your phone if you have a notary that swears you in. There's a lot of different ways to do it, but you can get somebody under oath and you can ask them a lot of questions. And about if you don't fight these, it can be very broad. And somebody giving carte blanche an allowance to ask you anything they want under oath is pretty scary. And I had a guy that did a Rule 2004 exam in federal court again. These kind of mirror each other because they're depositions that you don't really feel like you need an attorney for, because you feel like the person asking the questions doesn't have a lot of sway. And if they're doing it with just a phone in front of you and you're sworn to a notary, then it doesn't seem like it's that serious. And I'm here to tell you it's that serious. Anything you swear to that can be used in a court of law that's under the sort of the umbrella of a court, that a deposition, anytime you hear the word deposition, it's probably legal related. Take that very seriously and get an attorney to protect you and to fight it, and to object to questions that you don't need to answer, and to limit the scope to whatever it is that they seem to be going after. And that's what we did with this case. And so we had there was a land developer, D.R. Horton, that decided that they wanted to harass one of my clients and get his deposition on for no reason. I mean, they have $30 billion in their coffers. Why would they hesitate to file suit? They file suit all the time. But in this case, they didn't have a claim. And so they decided to go the route of running up the bill with a pre-suit deposition. And so we're going to talk about those a little bit so you can become familiar with what the rules are and when you can get them. And what I learned was that courts will grant these. There's at liberty. It doesn't seem like they will more often than not grant someone the sort of the permission rather than the forgiveness sort of thing. They're asking permission from a court, and they actually get a legal case number and everything. And you have to be served by a process server. They can get permission to come ask somebody questions, and that can be a benefit to you if you just want to bug, an ex-spouse, or somebody that won't leave your house, or a neighbor or a homeowners association. I mean, it can benefit you if you want to go that direction, because you can get up to 6 hours of interrogating a HOA board member, a neighbor, a relative, your employer, anybody you want. You can just go in and start asking them questions, and these are pretty freely granted from what I found. But if they are granted, then you need to get an attorney to make sure that it's limited. And so I'm going to tell you a little bit about those today. All right, so here is I got something on the internet where I thought it kind of crafted it and in a nutshell will say it better than I say it. I will tell you before I read this little article on it that if you go to the Rule 202 Texas Rules of Civil Procedure 202 is depositions before suit are to investigate claims. It was, I believe, codified in November or maybe in a statute in November of 1998, which was around the time that I was in law school, so I wasn't that familiar with them. Rule 202.1 says a person may, I'm reading this straight from the statute, a person may petition the court for an order authorizing the taking of a deposition on oral examination or written questions, either A, to perpetuate or obtain the person's own testimony or of any other person for use in an anticipated suit, or B, to investigate a potential claim or suit. That's the end of what you can do with that. That is very broad. That means that if they think they might have a claim, they don't even have to really have a claim. They can petition a court with a 2-page petition, and they're really easy. You can just Google it and find one. And the court will more than likely grant the authority for this person to interrogate you. So, and run up your bills and ask you questions. So do get an attorney if you get one of those, and do fight it. 202.2 says, the petition must, 1, be verified. Pretty easy to a notary to verify something for you. 2, be filed in the proper court of any county. It has to be a claim that be taken in state court if it's a state claim. I don't know that in federal court you can use a 202 deposition because this is a Texas rule. But if you have a claim, it's kind of very broad. So I believe that you could probably get into state court even with a federal claim if it's an employment claim. It needs to be filed in the county of the proper court of any county. 1, where the venue of an anticipated suit may lie if the suit is anticipated, or 2, where the witness resides if no suit is yet anticipated. So you can go to Travis County if they live in Austin. You can pretty much go to where they live and just interrogate them if your ex-spouse has moved there or whoever it is that you want to bug, all right? And I'm not advocating for that because I think they're very wrong. I don't think that people should be filing. I think if somebody's actually got a claim, they should just file suit, and they take their chances if they want to get sanctions against them. But 202 deposition suit, they are alive and well, and if you want to bug somebody, you can do this. C is it has to be in the name of the petitioner. That means the person's asking for it has to put their name. It's in re, whatever their name is. D, and they have to state within it either that the petition anticipates the institution of a suit in which the petitioner may be a party, or that petitioner seeks to investigate a petitional claim or against petitioner. That's a pretty easy thing. I'm literally, these are each one paragraph in the petition. So if you were to go, and if you have never seen one of these, if you just stated basically what this says and listed what you were looking for, you would get this. E, which would be the 5th paragraph, state the subject matter of the anticipated action, if any, and the petitioner's interest therein. So you wouldn't even really have, it says if any. You don't even have to state what the subject matter is. So it's really, really loose. F, if the suit is anticipated either, 1, state the names of the persons the petitioner expects to have interest adverse to petitioners in the anticipated suit and the addresses and telephone numbers of such persons. So basically, if they have gotten you and they're serving you, they already know this, and they're just stating it like with a little part of the paragraph. But they can also, if they think you're in collusion with somebody else and they are somebody that they can they don't have a standing, but if there's somebody that they want to bug, I guess, they can list them too. In fact, these petitions require that anybody that would be a part of it be included within the same petition, but usually if you're bugging somebody, you're only going after one person initially. The second prong to F is the state the names and addresses of telephone numbers of persons the petitioner expects to have interest adverse to the petitioners in the anticipated suit that cannot be ascertained through diligently inquiry, and describe those persons. So this is like a John Doe situation. If you can't find them, and I was going to talk about a suit today if we have time, where one of these 202 deposition suits was brought against a person through Google because they were defaming. If of course it was truth, it wouldn't be defamatory. But this very rich person, Robert Brockman, who is a resident in Houston, felt like somebody was defaming him on Google, and so he brought a 202 deposition, and he used this provision that says, it's a John Doe, we need to find him. And so they went to Google for Google to give up the name, and Google wouldn't. And just briefly on that case, it was really interesting. Robert Brockman was my dad's age, or is my dad's age. My dad passed away, but they both worked for IBM at the same time selling computers. He made a lot of money selling computers, and then he parlayed that into a different computer system called Universal System Corporation, and it made the computers for car dealerships where they could put information about the car in, and then put in their commission and be able to work with their inventory in the car. And apparently all car dealerships had to get a license for this. And this man made a fortune because everybody wanted this computer program. Since then, it has parlayed into a different type of program, and he sold it. But he's a billionaire now that lives in Houston, and he has other different I guess industries that he has worked in or developed, and he according to this blogger, he has not been fair to his employees, and this blogger might have been an employee. So Robert Brockman decided that he was going to get a 202 deposition to try to find out who this person was and sue him. Well, this went to court. It was granted. Then they filed a mandamus so that he wouldn't have to go forward, because they said there was a First Amendment right that Google does not have to give up the people the information of other people. It went to the Texas Supreme Court, who said, well, the court granted it. The First Court of Appeals affirmed it, so it was granted through them. It went to the Texas Supreme Court, who, by a split decision, said no, you can't get personal service on him because he lives in Oklahoma, so you don't get to take his deposition. And that is good law. And so a way to get around the 202 deposition is if they can't get personal jurisdiction. The problem with that is by the time that you get the deposition, you've already spent so much money on trying to fight this with the mandamus and personal service and all that. If it's really, is it worth it? And in our case, I might still do it just to fight it because I like having those sort of jurisdictional arguments in the courts. But you got a timing factor and you have to work really fast, and it's a lot of money. And so it may not be worth the money you're paying your attorney to fight for a mandamus not to be deposed, especially if you're not doing anything wrong. And this is just a harassment type suit anyway, a suit that they won't be able to go forward with. All right. So anyway, G for your petition has to include the names, addresses, and telephone numbers of the persons to be deposed, the substance of the testimony the petitioner expects to elicit, and the petitioner's reasons for desiring to obtain the testimony. So they do have to give you at least sort of a broad brush of what they're looking for, but it can be really broad, and they're permitted to ask you questions. And depending on how broad it is, they can ask you a lot of stuff that you do not want to disclose about your finances, your family, just basically anything. It's really bad. Even in court, you can object to relevance. So depositions are very, very broad. So do get an attorney for this kind of thing. And the reason I was talking about the Federal Rule 204 exam is that when we had done one of those and it was requested with the little phone and the notary before the trustee, it was the assistant trustee, it seemed so innocuous, the person being deposed didn't have an attorney, and he ended up locking himself into some statements that were really, really bad, that that proved that he had committed fraud and broken some laws. And so had he had an attorney there, objections would have been made that would have prevented that. So that's why I'm saying, once again, if you get locked into one of these depositions, definitely get an attorney, even if you've done nothing wrong. This guy was asked questions that had really little to do with what the deposition was about, and he got himself in trouble. Okay, the next thing that has to be in this petition is you have to request an order authorizing the petitioner to take the deposition named in the petition. And so basically, this is where you're asking the court to order the deposition be taken, because third parties can't be brought to court unless you subpoena them. They're usually subpoenaed if a suit is already in place. And in a regular deposition, if you're a party or a witness, you can be a party and a witness. It's just a part of the rules that you can be deposed. If you're a third party and just a witness, you have to be subpoenaed, but you can still be brought into it, and usually you can't avoid it. If you don't even have a suit, then you don't have a case to work with. There's a subpoena to have a case to work with, and that's what the 202 deposition is for. It's to create a suit for the sole purpose of getting a deposition. The next thing is they have on 202.3 is there has to be notice and service. And this is where the Google case that I was talking about would not have had couldn't have gotten into court. This prong of Rule 202 provides that personal service on the witnesses and person's name must be had at least 15 days before the date of the hearing to find out if you're even going to have a deposition on the petition occurs, and the petitioner must serve the petition and the notice of hearing in accordance with Rule 21A, which is the Texas Rule of Civil Procedure that tells you how service needs to occur on all persons the petitioner seeks to depose, and if suit is anticipated, on all person the petitioner expects to have interest adverse to the petitioner's suit. Long way of saying that they have to serve you. Well, Rule 21A says you can actually for personal service, they have to do certain things. They have to actually hand it to you. If they can't get it, they have to have substitute service. In our case, they couldn't serve the person they were trying to depose, so they got substitute service. But in our case, they didn't follow in any way the rules of substitute service. But the judge in Montgomery County decided that he didn't care what the rules said. He said, I'm saying you're served. And so we could actually fight that in court and win, that there was no personal service. But again, it's what the economies of scale. Do you want to actually fight that you didn't have personal service and prolong the inevitable that they'll eventually get personal service and piss off the judge? Or do you want to just go ahead and say service happened. Well, if you really need to avoid service, then you want to keep fighting this if there's something that you do not want to disclose. But if you don't have anything to disclose, don't save your money and just go to court. It's just not that big of a deal. But do get an attorney when you go to the deposition. All right, so service by publication and person is not named, and this goes towards like the Google thing. A person can get publication service, but you have to actually file for the court for that too. Service in probate courses, probate cases, and this is another time when the 202 would apply. You don't know who the people are, but you want to get information, let's say, on a trust that you may believe that you're a beneficiary in. You can't just sue a trust. Trusts are very protected and they're confidential, but you can if you believe that you're a beneficiary of a trust that was created that you're not being paid out on. And so that's what happens in these probate type situations. A petition to take a deposition in anticipation of an application for a probate of a will or the notice of a hearing petition may be served by posting under section 33F2 of the probate code. And it's actually, this is an old article, even though it was just written, because there's no probate code anymore in the state of Texas. It's called, since 2000, I believe it was 16, it's called the Texas Estates Code. But there's a little chart, if you go to the beginning of the code, that tells you what the old code was in probate and what the new code is in the Estates Code. There can be a modification by order as justice or necessary may require. The court may shorten or lengthen the notice periods under this rule and may extend the notice period to permit service for any unexpected party. The order will come through the court and will tell you when when the deposition will be taken, the manner it will be taken, the use in which it will be taken, and that is, without even reading what this other article said, that is the gist of Rule 202. But I'm going to read this first paragraph of this article because I know I've got to wind it up. The procedure rules are generally complex, like we just read, and confusing to non-lawyers, but Rule 202 of the Texas Rules of Civil Procedure must certainly befuddle everybody, and I just read that to you. And it doesn't really befuddle me now that I've read it to you, but if you were to get this petition in the mail, it would be very confusing to understand that you're being asked to be given to your deposition be taken for something that doesn't, that they have no business to even, or standing or privity to even ask you about. So it makes no sense. So I'm getting the wind up notice from Dick. So I'm going to read this last sentence, our station manager. It says, so this is when you get this, it says, so I'm being sued to find out if I can be sued. That's what a 202 is. As such a potential defendant could arguably be justified in viewing the Rule 202 as a costly excuse to grant permissible fishing expeditions for frivolous lawsuits. That's exactly what they are. Texas is certainly the Wild West when it comes to availability of pre-suit depositions. In fact, Rule 202 in Texas is understood to be the broadest state grant of investigatory discovery to private parties in the United States. So we need to change that. However, the rule serves an important function and contains some procedural protections that should be utilized by recipient by such petition, and we just went over those. So it needs to be very well defined on what they can ask you and only what they can ask you. Get an attorney if one of these things sticks and you've got to go get it done. Usually, if they have a claim, they're going to sue you. I've never seen any 202 suit other than for the Google case, and it still didn't work for them. That passes muster. But if you have any other questions, contact me on Facebook. I will see you next week. We'll talk about homeowners associations, and remember to serve God by serving others.